Well, hello seniors, and welcome to the Central Bucks Senior Task Force. We meet here on the first Monday, most first Mondays, of every month at 1 p.m. at the Central Bucks Senior Center, which is at 700 North Shady Retreat Road, right here in Doylestown, right off the bypass. So please come and join us. Have lunch here and then join us for our session at 1 o'clock. And we're on every day at 10 a.m. and 10 p.m. on both Comcast and Verizon, so I'm glad you're with us. And today we have Don Petrille. And Don is, well, we're going to let Don tell you what he is and what he does, but welcome.
Thank you, Kevin. Thank you very much. And it's a pleasure to be here at the Central Bucks Senior Center and to see so many friends around here. I've had the pleasure to speak here before, speak about what our office does. I am the Register of Wills of Bucks
Now, don't
County.
get ahead of me now.
Okay,
Don't
I'm
get
sorry
ahead of
about
me,
that.
Don. No. So let me rein you in a little
All
bit.
right.
All right. So you said you're, and you can just talk with me here, Don Petrille.
Yes.
Jr.
Junior, yes.
Okay. Esquire.
I am an attorney, yes.
Okay.
Yes.
So
Don't hold that against me.
Never?
Okay.
Never. Some of my best friends are attorneys.
Okay. Mine too, actually.
My best man and the guy that last married me, so we're in good shape. So let's just talk about it. The Bucks County Register of Wills.
That's correct.
Are you in the old courthouse or the new one now?
We are still in what's now known as the administrative building, which a lot of people are still calling the old courthouse. So
Okay.
we're still on the third floor of the Bucks County Administration Building, same place that the office has been for about 50 years.
Okay. Now, I'll always call it the old, but it's not the oldest of the courthouses, right?
Oh, certainly not, no.
When was, do you know when Bucks County, had its courthouse placed in Doylestown? Are you familiar with that at all?
I believe that happened in 1812. I believe we just celebrated.
When the British came over.
Well, I'm not sure if they were related, but it certainly was moved in 1812, and I believe the borough had a very nice celebration about when the courthouse was
Okay.
moved to the 200th anniversary of when the courthouse
yeah.
and the county seat was
yeah.
moved.
I was here
was
for that.
moved up from Newtown.
Okay, got it.
So sorry to our friends in Newtown if you're watching. I know this is Central Bucks, but
we won't
Doylestown's
worry
had
about
it for
that.
203 years, going on 204 now.
That's crazy. So tell us a little bit about the Register of Wills and what that means, and all that you do. There's probably like a key areas, right? You've got something having to do with wills. You've got something to do with marriage licenses, and maybe something else.
Sure. It's a very diverse set of duties in the Register of Wills office.
Okay.
And we are the only office in Bucks County government, the only elected office, I should say, in Bucks County government, which actually has two offices associated with it.
Okay.
The full title of the office is Register of Wills and Clerk of the Orphans Court. So it's got two separate constitutional job duties under the Pennsylvania Constitution where the offices are established.
Okay.
And every county in Pennsylvania has these offices, along with the many what are called county row offices.
Why do they call it a row office?
Well, in most courthouses, all of these offices were in a row
Okay.
along the along
thought
the
you
first
didn't
floor.
do this.
No, we were never.
It feels like that sometimes.
that'd be a lot of exercise.
Okay.
But the Register of Wills office, which the shorthand for our office, is responsible for the probate of wills and the appointment of administrators. That's a fancy way of saying that when a decedent's estate needs to be raised.
Okay, when somebody
passes-
dies.
When somebody passes away,
Okay.
and there's a will, our office appoints the executor of the estate.
So let me stop you right there.
Sure.
When somebody passes away, whether they have a will or not, they always get somebody assigned to them in your office?
Well, if they have a will, we'll start off with when they have a will. The will could, most of the time does, appoint that person that the person who passed away, we call him the decedent.
Right.
The decedent wanted to be the executor of the estate.
Okay, so an executor and executrix, right? So executor is typically male and executrix is a woman?
That's correct.
Okay.
That's correct. So that will document will say who we should appoint. So
Okay.
our only duty at that point is to decide, is this will valid? To probate means to prove.
I put probate here because we hear that term a lot.
Mm-hmm.
Why don't they just say prove?
Be honest with you, I do not know why
Okay.
I don't know the etymology of that word.
Okay.
But probate means to prove, and it is then becomes a legal document. A will is not a legal document in the form that it is not binding
Okay.
until it is presented to the Register of Wills
Okay.
and admitted to probate. So when it is presented to the Register of Wills and admitted to probate, then
Right.
it becomes a legally binding document that the executor of the estate needs to follow the instructions in that document. So that's the first part of opening an estate, is when
Okay.
the executor will bring the will to the Register of Wills office and become appointed as the executor or executrix of the
Okay.
estate.
Okay.
You can have co-executors of an estate as well.
right.
So two or more people may be appointed. And that is certainly creates some of its own challenges
Okay.
at times. If the
People
two-
having to agree.
Exactly.
Okay.
And sometimes they're there to, the decedent wanted there to be a check
Okay.
on each person. So so it did require two sets of eyes on a
Counterbalancing
transaction.
check.
That's right.
So let me just ask you a couple questions about that. So typically, people have a will written, but not always. So, but let's start with the person, because our audience, hopefully everybody has a will. But let's just say that when somebody passes away, they find the will, because, maybe it was in a drawer, or, who knows what. Is somebody supposed to physically take the will to your office?
That's correct.
Okay.
We probate original wills only.
Okay, so would it, I guess sometimes it comes from the lawyer who created the will, and sometimes it comes from a family member or even a medical professional if the person lived by themselves and they found a will?
Well-
What happens?
One of the most important things that we can advise people to do is to know where your original will is.
Okay,
Because our office, as I had mentioned, Kevin, we can only probate an original will. If there is no original will, there's only a photocopy of the will. The presumption is that the original will was revoked. Either the decedent had destroyed the will or purposely hid the will, but did not want that will to be admitted to probate. So one of the most important things we can do is know where your will is, whether
Right.
that is with an attorney who drafted it or
Right.
whether it's in a fireproof safe
Safe
or
to
other
deposit
safe
box, maybe?
under the mattress. Sometimes
Right.
people do, but know where that document is. Safety deposit boxes can be tricky because sometimes after somebody dies, it could be tricky to get into that safety
okay,
deposit
that's a whole
box.
nother issue.
Whole nother issue.
Okay,
So we definitely want people to know where that document, where that original document is.
right,
Now, there is a way to get a photocopy admitted to probate, but it is a much more involved legal procedure, typically a little bit more expensive,
Okay.
and often people do need to involve a lawyer, where otherwise they might not have to involve a lawyer. Again, if they know where their will is, and importantly, tell somebody where it
I was
is.
just
Tell
about to
somebody you
say, right?
trust.
It's okay if you know where it is, but if you've passed away,
You're not saying much.
no, tough, right?
Right.
Okay, so can you log it with your office ahead of time?
No. And again, this goes back to that concept that a will is not a legal document until it's been admitted to probate.
Okay.
And anyone can change your will at any time. Lord knows that I've seen a lot of situations before I became Register of Wills when I was in my private legal practice where I would have a client who would get mad at a niece or a nephew and cut them out of the will, and then maybe 2 or 3 weeks later think it was a rash decision, and then maybe 6 months later cut a different niece or nephew out of a will. So all of those different wills,
Okay,
only the last will is the will that we would want to admit to probate,
okay,
and that would allow somebody to change their will. Also, if a document is recorded in our office or is
Right.
admitted to our office, what that does is that document becomes a public document. And there are very few people who want their will to be a public
see.
document before they pass away.
okay, so that all makes sense to me.
Yeah.
So, so they go through the process, the will gets to, if there is a will, the will gets to your office, it goes into probate to prove that the will is what, accurate or legal?
That it's
or
original.
It's
That
that's
it
what you're
is-
proving,
it- yes.
originality.
It is the decedent or the testator. A testator is the person who writes a will.
Okay.
So it is that person's actual legal act. And how we prove it, it's actually quite a simple process. Any document that is written that is designed that after somebody's death to give away your property can be considered a will.
Okay.
It may not be a complete will.
Could be on a napkin.
We've had napkins. We've had
Cocktail napkins?
cocktail
See,
napkins.
those are the ones that I want to read.
Well, then we get into some issues with what's called undue influence and capacity if it's
Okay.
the cocktail napkin.
Okay.
So we got so that becomes another issue as to whether or not it is. But if two people come and say yes, that is the decedent's signature at the end of it, and they identify that signature, and they sign an affidavit in our office, then the will is presumed to be the valid act of the testator
Okay.
at that point in
Okay.
time. Now, most of the wills that we have that are prepared by attorneys that will be signed at the end by the testator,
Right.
and then two witnesses will sign those wills in
Okay.
advance.
Okay.
Then the attorney will usually prepare an affidavit that they'll attach to the back. It's called a self-proving affidavit. And that affidavit the testator will say, yes, I signed this will. It was my own act. I was under no coercion, no undue influence.
Duress, no duress.
And this is the act that I intended. It's not the
Okay.
exact language, but there is a exact language specified by the probate code. Then the witness will say, we were present when the testator signed the will,
Okay.
and he was under no constraint, no undue influence, no
Right.
duress,
Right.
and to the best of our knowledge, he's legally able to do this. And then they'll sign it, and then both of those statements will be notarized. If we get a will that is properly witnessed with that attachment to it,
Right.
we don't have to go and find those witnesses and bring them into the office. It's a much more simple procedure in
Okay.
order to get a will admitted to probate, because you've done all of your work up front. If we don't have that document,
Right.
and we still have the two witnesses, we need to be able to find the subscribing witnesses. They need to sign a separate affidavit, and they bring them in. So it could be a little bit more legwork for the executor.
So bottom line is, get a will,
Get a will,
get it, sign it,
sign it,
keep it current,
keep it current.
have witnesses,
Yes.
and know where it is, and be able to tell somebody that will probably survive you where it is.
Very good, yes.
Okay.
We had if I could just share a quick anecdote about
Yes.
a story that I had heard. There's a family, it was a nice Italian family, and I can say that I come from a big Italian
right?
family. Yes.
Okay. Yeah.
And one of a lady, she had 9 brothers and sisters. I don't know how many nieces and nephews that she had, and some of them had passed away. And one of her nephews who took care of her knew she had a will. He knew that this lady had a will, and she passed away. They couldn't find the will. They couldn't find a photocopy of the will. The attorney who had drafted it was out of practice and didn't have anything left over. They knew she had this will.
Right.
Well, she didn't tell any members of the family where this was. So they went ahead and administered the estate without a will, which is called an administration.
Okay.
And they had one of her sisters appointed as administrator of the estate. And we can talk about that procedure a little bit if it's a
Maybe.
preview of things to come
Maybe,
on our
yeah.
discussion. The administration went the way that it should have, and all of the nieces and nephews were getting their appropriate share if a brother and sister hadn't passed. This is an older woman, so her parents had predeceased her, and she didn't have any children, and she was never married. Well, my friend was moving out after they actually had sold her house.
Yes.
Moving everything out, and a lot of the personal property was being divided among all these nieces and
Oh,
nephews and brothers and
I've
sisters.
been there. I know what that's
Okay.
like.
And as they're pulling out the refrigerator, they see the cooling vent in the back, that kind of
Yeah, yeah,
cage.
yeah.
And all of her important papers were back there. It was her will, the deed to her house, her insurance policies. This was her filing system.
Yes.
And the lesson to take here is that it was safe, it was secure. There's nobody who was going to go and try to find that will.
Right.
But it wasn't practical because the people who needed access to those documents at the time they needed those documents
Right.
didn't have access to them. And then the family worked it out without having to admit the will to probate. There was a lot of legal wrangling that went on, but it was a very, very caused a little bit of consternation that didn't need to be covered. And the moral of the story is, tell somebody you trust where the document is.
All right. Well, let's talk about, that's good stuff. Let me ask you a little bit more about the will, and then we're going to look at some other things.
Okay.
But you may or may not know, but I run something called the Dementia Society of America.
It's actually how we met.
That's right. That's how we met. I almost had forgotten. But in running that organization, we end up with people that either think they have dementia, may have it, or are concerned that they would have it in the future.
Right.
And so, from a will standpoint, what is suggestion? First of all, always do it before you have any type of diagnosis of
Absolutely.
a dementia, right?
Yes.
But do you end up having that as an issue in some of the probate that goes on?
Sure. There are ways to challenge a will, and one of the interesting things about the Register of Wills office is that I get to act as I don't want to say a judge, but certainly as a hearing officer often. It's called a quasi-judicial office. So there are times when somebody doubts the authenticity of a will, either in advance before it was probated. They say, don't admit this document to probate. They'll file a document with our office. Or after it's been probated, then the Orphans court would have jurisdiction over that type of an issue, whether that document was valid.
Okay.
And if it has those two witnesses, and those witnesses have said that, yes, that is the decedent's signature or it's self-proving, the will is presumed to be valid. Now, so
Okay.
you have to, you have to, as a person challenging the will, bring an action to try to show that that will is not appropriately admitted to probate. And when you're talking about people who are possibly not having capacity, there are
Right.
two kind of bases for that. The first is called lack of testamentary capacity.
Okay. Big fancy words
Big
there.
fancy word. It means that the person at the time that they signed the will, they did not know who their natural heirs were.
Okay.
Whether they be family members or friends or people taking care of them.
Okay.
It's different for every individual, but
Right.
the people that somebody, a third party, looking at this person would say, well, it would make sense for them to give their estate to that person.
Okay.
So that's one element. If you have to know who your natural heirs are.
Okay.
The old term was natural objects of your bounty.
Oh, beautiful.
Yes, but your natural heirs.
You're not going
is
to
a
get into
better-
loincloths.
No,
or
we're not going to
anything.
do
Okay.
that. No,
All right, good. Keep going then.
we don't run that kind of operation.
Got it.
And the other thing you have to know is you have to know what you owned when you're writing the will.
Okay.
That's the second issue. So if you think you have this huge estate and you're an heir to some large fortune, and you're a person of modest means who lived in Bucks County and worked a good career,
Right.
but all of a sudden you think you're either richer than you are, or even if you think that you're a lot poorer than you are, you don't own as much as you think that you owned, then you may have a capacity issue. The final issue with that is at the time that the person is signing the will, not necessarily before they sign the will and not necessarily after they sign the will, but in the window of time as they're signing the will, did they understand what was in the document? And did they understand that their property, as they know it, would be going to either the natural heir or that they were purposely cutting out that natural heir?
Okay, so let's recap that.
Yeah.
So, at the time that you sign the will, you need to know who things might go to, who your natural heirs might be. That was number one.
That's correct.
Number two was you have to have a realistic understanding of what you own.
That's correct.
And then number 3, you have to understand what's in the document and how it's giving things to different people.
That's correct. And you don't have to know it at some technical level.
Right.
Because most people who have capacity may not understand the technical way some legal language works in a will. But you have to basically
The
know
essence of it.
the essence of the document. I know that I'm giving this money to these people in these percentages.
Okay.
And I know that there may be a trustee, it might be going to them outright. I know that I'm cutting this person out of my will, and I'm doing that on purpose. Or I'm giving this gift to this person who was very kind to me during my life. You have to have an understanding
Right.
of those things.
That's
So that's capacity.
Seems like you probably at times, and maybe your staff as well, run into some pretty emotional environments.
Well, when
With family, being cut out, or people getting things that they didn't expect to get, pro and con, right?
Right. Well, when a will becomes something other than a ministerial decision, just to, hey, this is a properly witnessed will, there's no contest, there's no
Right,
drama.
right.
Those wills are handled by our staff, and our staff, we have a staff of about 19 people that do a lot of.
19?
We have
For all of Bucks County.
For all of Bucks County,
Okay.
we have an office down in the Levittown Government Services Center that does about 20% of our wills.
Okay.
And we have a staff that handles a lot of the clerk of the Orphans Court duties as well, and a lot of our collection of $55 million of inheritance tax.
Oh, well, let's talk about that for a second.
Okay, sure.
$55 million? What are you talking about?
Bucks County citizens pay about $55 million a year.
A year?
A year in inheritance taxes to the Commonwealth of Pennsylvania
Wow.
that our office collects. Now, the good news, Kevin.
Is that why the sheriff's always there with the bags to hold the bags?
Well, we have the security officers. Yeah. The sheriffs don't help us out on that
$55 million.
$55
That's $1
million
million a week.
About that, yes. We have
That's a lot of dough.
it's a lot of money.
Okay.
It's a lot of money.
So has that fluctuated over time, or?
It's been going generally up, but it is economically sensitive.
Okay.
Because as real estate prices go up and down, the tax burden on real estate would go up and down. As the stock market would go up and down, it's
Okay.
been down the last month. It was up for a couple years. As the stock market went up and down, and people have investments that are market sensitive,
Right.
well, that will affect their tax burden because it's just a percentage of the fair
Taxable.
market value on the day that they died. That's the tax burden.
So if I understand it correctly, today anyway, this is 2016, there's about a $5.2 million kind of non-taxable amount for a couple. Is that
Okay.
true? Or
That-
is that per person?
Well, that's a great question, and this is one of the things that we do
I only
have.
ask great questions. Now go ahead
That's
with
true.
a great answer.
The great answer is that the number you're speaking about is a federal exemption.
Ah, interesting. Okay.
So that's the
all right.
federal
I think our viewers
estate
need to
tax.
understand that.
So there are two sets of death taxes that you may experience. The first is the one that Kevin just alluded to, and that would be the federal estate tax. And you have about a $5.2 million exemption. It's indexed for inflation. It goes up every year.
And that's per person,
that's
so it'd be
per
10
person.
point something for a
10.4
couple.
for a married couple. That's
Okay.
correct. Not many people in Bucks County have to deal with that issue any longer in our experience, but we do have some taxpayers that do have to deal with that. We do not collect federal estate taxes. That's done by the IRS.
Makes sense.
We're not an agent of the
Okay.
IRS. We're only an agent of the Pennsylvania Department of Revenue. Now,
So tell me, what's the tax burden from a Commonwealth standpoint?
From the Commonwealth standpoint, we have a graduated inheritance tax.
Okay.
It's 4.5% to children. It's 12.5% to brothers and sisters who might inherit. And this is of the fair market value on the date of death. And it is 15% to everybody else. So that is, as you get farther away in relation, the tax goes up. Now, there are two recently passed exemptions. And these were designed to save family businesses and family homes from extraordinary tax burdens. First is the farm exemption.
Okay.
So if somebody's family is going to inherit a family farm and keep farming or continue in the
Yes.
business of agriculture, that farm and the business of agriculture is conceivably going to be exempt from.
And we have a lot of farms here in Bucks County.
And we've been doing a great job in Bucks County preserving those farms
Right.
and preserving our agricultural way of life here in Bucks
heritage.
County. The second thing is the small business exemption.
Okay.
So if you own a small family-owned business and that business is going to be run by a family member, a child, I believe it goes down to niece or nephew,
Okay.
aunt or uncle. If you're in that situation, that family-run business is conceivably going to also be exempt from Pennsylvania inheritance tax as well.
Okay,
It's very
interesting.
complex the way
Okay.
that it's all administered, and if you have that type of an issue, it's definitely good to talk to a good tax advisor or an attorney in that situation. But those are things that are designed to keep our small businesses in business after the death of an owner, and also to keep our family farms in the business of farming instead of becoming developed into real estate to pay the inheritance taxes.
So, Don, help me understand things that are more material in nature. So, if you had a painting or you had a special, some other piece of artwork or a collection of some kind, and you wanted to give it to your grandson, granddaughter, somebody in your family, how is that taxed? Similarly?
Well, you would then need to get an appraisal or some type of statement of value.
Okay.
And then you want to attach that to your inheritance tax return.
Okay.
And that way, that would make it easier for the inheritance tax agent who's going to review your return if they see a piece of art and revalued it at $5,000. And you had a letter from an appraiser,
Right.
Or you had one of the things people do, especially with collectibles, is they'll attach completed sales from eBay. How much something was sold, because that is a
Recently. Okay.
recent market value of what something might be worth when they're looking
But
establishing
does
a tax
that
value.
mean, Don, that if somebody got that painting and it was worth $5,000 at the time of death, and they would owe, if they were not close relatives, but let's say further out, or maybe not a relative, a friend, they'd owe 15%, or the estate would owe, who would pay the 15%?
And on that, it really depends. It depends on how the will is written.
Okay.
Many wills are written to say that any inheritance taxes or federal estate taxes are an obligation of the estate. I'm not going to put that burden on my heirs.
Okay.
But many wills say, especially wills that may divide up among different classes of people. I may be giving part of my estate to a son or daughter. I may be giving part of my estate to a spouse. And spouses are taxed at a 0 rate in Pennsylvania. So there's no, what they
Okay.
used to call to the widow's tax.
Yes, right.
So that is a good feature of the law. But especially if there are many heirs taxed at different rates, they may say that the tax is to come out of that person's share, or that person is to pay the tax on their own. That can be a clause in a
But it's
will.
not common, I guess. I mean, I just had my will written, actually,
Right.
a couple weeks ago. So, and I don't remember a clause like that. So,
I would say that it's up to the person who's writing the will and what the attorney who may be helping them out may want to do. But the more common, I do believe the more common provision is that all estate and inheritance taxes would be paid out of
The
the
estate.
estate by the executor. or
one
the
last
administrator.
question on this. Then, if the person had nothing else, but still gave that painting, had no real assets, they had ended up, long time spending them down, and they just had a few $100s left in their bank account, or. So now, what does the Commonwealth do?
Well, it's possible that that asset could escape tax, and that is because there are some reasonable deductions from the estate that are not taxable. To the extent that you have to pay funeral bills, costs of probate to our office,
Okay.
attorney's fees, accountant's fees, certain bills that are associated with a last medical emergency, your last illness. There are certain administrative expenses that are deductible. If the decedent had any debts that are going to be paid, or even if they're not going to be paid, those may be deductible from that from the cost of that. So if the person had a $50,000 asset and they had maybe $35,000 or $40,000 of expenses and deductions, there may only be tax on the $10,000, the net value of the estate.
So bottom line is it gets a little complicated.
It does.
So, think about meeting with an attorney to talk about it, so you do these things correctly, and that the people that you intend to give things to get them the way you want them to get them, and that you kind of, cross your T and dot your I. Let's turn to Orphans Court, because that's the other thing that's... But before we do that...
All right.
I was doing a little research.
Okay.
And it almost amazed me. I mean, we're very lucky here in Bucks County because we've been here since the time of William Penn.
Mm-hmm.
And your office is like one of the oldest government offices in the country.
That's correct.
Tell me about that.
Well, Pennsylvania was founded in 1682 is when our charter was signed.
Okay.
And the first will in Bucks County was probated in 1684. The decedent's name was Alexander Giles. We do have...
I think he's a long-lost relative of mine.
Okay.
Kevin Giles Jameson.
Oh, all right.
Yeah.
Very nice.
Yeah, let's talk it later.
Yeah. And Mr. Giles' will is the first will here in Bucks County, and was probated by the first general register of Bucks County. His name was Phineas Pemberton.
Beautiful.
And Mr. Pemberton had responsibilities for the probate of wills, for the recording of deeds. He was the clerk of all the courts as they all got set up. And he also kept a great book, which is kept over in the Spruance Library of the Mercer Museum, which is called the Book of Arrivals. And he kept a very, very detailed account of everybody who came through the port of Bristol into Bucks County, who they were, where they came from, and how many servants they brought, how many family members they brought. It's a very, very interesting document. It's hard to get your hands on that because it's in very, very frail condition. It's a 330-year-old document, so it's in very rough shape. But there is a history of Bucks County where it was transcribed in it by an author called J.W. Battle. Mr. Battle wrote a history of Bucks County in 1882, which was the bicentennial of Pennsylvania, and it's a 1,500-page book about this thick, and you can get that at some of the libraries around here. Battle's History of Bucks County.
Beautiful.
Would be able to.
You've
get
read
that.
it cover to cover.
Cover to cover.
Beautiful.
It is one of the most complete genealogies of Bucks County families that you'll see as well. It's interesting.
So, and let's touch on one more thing before we go into Orphans Court, and that is because you just mentioned genealogy.
Right.
So, do a lot of people come to your office because of that?
We do. We get a very sizable portion of our customers are coming specifically to research what was in a will from the 17th or 18th centuries. If they have people who passed away in Bucks County or wrote a Bucks County will. We also have historians and historical sociologists come in because particularly in the 18th and 19th century, when an estate was administered, and somebody may have been in business, if they were a farmer or maybe they were a blacksmith or they owned a shop, very few people did business through a corporation. They were mostly sole proprietorships.
Right.
So you owned everything in your business personally. You didn't own it through a corporation. So we have estate inventory records that show how many eggs were in somebody's larder and how many bushels of wheat and how many sheets and how many pieces of silver they had in their houses, or silverware, flatware. It's really fascinating to see this. It can be an insight as to the way people lived and the way people worked, and all of those records are in our office. And I'm very pleased to tell you right now, we are in the process right now of getting all of these records online.
So let me ask you about that. So online, the like Ancestry.com, we're not making a plug for them, by the way. And the Mormon Church is very much involved in this because of their belief system in the genealogy of things. So do people come in that are kind of out-of-towners to do that, to come in and scan and put things on, or are you just doing this in addition to that?
No, we have a sizable amount of people who are out-of-towners. we had a longtime clerk who just retired in January, who part of her job was to help people find those records. Because some of the older indexing systems to find these types of records were kind of difficult to use.
Right.
There's, you'd have to go to an index book, and then you have to find out where the will is, and then you'd have to find the right piece of microfilm to get a copy of the
Okay.
will or the right file. And maybe that file might be in our storage facility on Alms House Road. It might be in the courthouse. It might be at the Spruance Museum. So there's or Spruance Library.
Right.
So we had somebody help people out, and that wasn't her only duty, but she was very, very good at that. But right now we are working with Keymark Incorporated. They are a vendor that has a contract with our office that the commissioners were good enough to allow us to go forward with.
Okay.
And they are scanning our entire will collection up to about 1988. So from 1684 to 1988, we are very much hoping to have all of those wills online and searchable by the end of this calendar year. That is our goal.
And so it's a little bit different than the birth and death records.
That's correct.
It's an addition to, I guess.
Yeah, our birth and death records are actually quite sparse.
Okay.
The death records in our office are not public records, so to speak. We can't copy the death certificates. They are in as our files as proof of death. If you need a death record, you need to go to the Department of Health's, Pennsylvania Department of Health, not the
Right,
Bucks County
right.
Department of Health. Their Bureau of Vital Records.
Okay.
That will get you death certificates and birth certificates. We have birth records for about a 20 or 30 year period from about 1885 to about 1912 or so. And those records were kept at the county level for a small period of time
Okay.
through the clerk of the Orphans Court.
And do those records, like one time I went to Sweden to look up some of my relatives.
Yeah.
And, went to this little island of, in the middle of the Baltic Sea and found this, kind of a register of wills there.
Yeah.
And actually showed where people lived and that type of thing. So does anything like that exist? Kind of like parish records almost. I guess we don't really have that, do we here?
Our records are mostly confined to that limited amount of birth and death records that I had alluded to, the wills, then the inheritance tax records, in the inventories, and then we have our Orphans Court records, which are the records of the court proceedings that affect estates.
Okay.
The Orphans Court, like Bucks County itself, dates back to the 17th century. That's why we have this name. In some states, it's known as the probate court. In some states, it's known as the Probate Estates and Trusts Court. That court has jurisdiction over any dispute involving an estate. It also has jurisdictions, as the name might imply, over adoptions. It also has jurisdiction over the appointment of guardians of incapacitated people. Now, that's incapacitated people at the young age. You're deemed incapacitated before you turn 18, so you need a guardian to look after you if your parents are not
Right.
around or your parents aren't doing a good job. So you may have a guardian at that point.
Right. Mm-hmm.
And then at the other end of the spectrum, if we have somebody who is through sickness, disease, injury, can no longer take care of themselves, whether that's not take care of their body, their person, or whether that's of their financial affairs, and those are two different types of guardians.
Right.
That Orphans Court has jurisdiction over that. And then naturally, if somebody is through age experiencing maybe dementia, senility, some type
Right.
of
Dementia.
some type of lack of capacity because of
Cognitive difficulty.
cognitive difficulties, then the Orphans Court still has jurisdiction over appointing a guardian to those people as well.
Interesting. So now my mother was an orphan,
Okay.
and she was put in an orphanage with her brother back in the 20s.
Yeah.
It was because her father passed away during the Depression.
Mm-hmm.
And at that time, I'm curious if it's still true, that it was because her father passed away, even though her mother was still alive, she was still considered an orphan. Now, is that true today or no?
Not as much,
Okay.
because parents have equal rights to their
So it's
children.
changed.
It's changed a lot.
Okay.
And then we also have a much more robust, when somebody loses both parents, we have a much more robust social services system now, where there's foster care and group homes.
Okay.
And our office is very much involved in trying to promote adoption and for people to be involved in the foster system if they have
Okay.
capacity, love, and the ability to really affect a child's life who may need that.
Well, I think, we're going to wrap up in a couple minutes, but the one thing that I know our viewers and our audience here, they'll want you back. So
Okay.
just be aware of that. Let's turn to one last area we haven't touched on, and that's marriage licenses.
Sure.
So why the combination of marriage licenses, orphans court, and wills?
Well, most of the life events in somebody's life was happening in the Register of Wills and Clerk of the Orphans Court. And in the 19th century, when marriage licenses became a legal requirement, it felt right to the legislature to put that responsibility. It certainly needed to be done at a county level.
Right.
And put that responsibility on a county office. And the Clerk of the Orphans Court seemed like the best office because they were also keeping, at the time, birth and death records.
Okay, so it's a life event.
So it was a life event, that's
Okay.
correct. And they were then being indexed. Now, that responsibility in the 20th century for birth and death records was taken away, but the marriage license records have stayed. So we have marriage licenses dating back to the beginning of the marriage law in the 1880s.
So what was interesting, and what I learned when I recently got married in October, and lovely wife, by the way, just a great situation. But the issue was I found out that there were two different types of licenses,
That's correct.
and it's kind of unique to Pennsylvania. Maybe there are other states, I don't know, but this is like somebody said, "Oh, you need to get a Quaker license," and I'm like, "What are you talking about?" Oh, yes, it's because William Penn and the Quakers, that you could basically self-marry.
That's correct.
You don't need an officiant. You just need somebody to witness it.
That's correct.
And so that's what we did,
Okay.
just because it was different. It was interesting. Even though we had an officiant, he was just kind of icing on the cake.
Okay.
It was just for fun.
All right.
Just for him to be up front. And so describe that for me and why that is and how, do people take advantage of that? Is there a reason to do it? And, some of our viewers, even though we're seniors, we still get married.
Right.
So is there a reason to do that?
So we have the self-uniting marriage is the Quaker license, and the requirements for that license is that the bride and the groom would get together, and they'd have two people witness their exchange of vows, and that is consistent with the way Quakers married from the 17th century. So that's why that has been a robust part of Pennsylvania law since the founding of the Commonwealth. The more common manner of getting married is with an officiant, whether it is what's called an elder of a religious domination. They define in the statute a religious domination as having a congregation.
We're not going to talk about religious domination.
No, denomination.
Denomination.
Denomination,
There
not
you go.
domination.
Right.
So that's the more common kind of ceremony that people are acquainted with. Now, what our office doesn't do, we do not opine on the legality of a marriage.
What do you mean?
We don't tell
Describe
people. Some people say, well, if this person marries me, is that okay? What we'll do is we'll give them the statute.
And then it's kind of their choice.
It's their choice. You're
You're not peeking in and saying, how did you really do this or any of that.
And some people have various religious beliefs, and whether or not that elder of that particular religious denomination qualifies under the law is not something that we're going to get into. That's something that we really feel that that's up to the people getting married. That's up to the person performing the ceremony, that whether they believe they're qualified under the law.
Interesting, okay.
And really, where you really get that issue, if you're going to get that issue, is if somebody wants to go and dissolve the marriage and somebody wants to claim they were never married in the first place.
Interesting.
So that's the issue, and that would also be under the Quaker license, is whether or not those witnesses did what they were supposed to do, and the vows were exchanged, and it was within the statute. We don't police the actual ceremonies. We only make sure that the licenses are given out according to Pennsylvania law.
So is that unique to Don Petrille and your office, or is it kind of generally that way throughout Pennsylvania?
It's generally that way throughout Pennsylvania. In fact, our Association of Register of Wills throughout the state and Clerks of the Orphans Court, to be more precise,
Right.
The lawyer for our association says you are not the marriage police. You know,
Okay.
people have lawyers, people have officiants. Some officiants have licenses, some have commissions if they're a judge or a mayor.
Okay.
So it's not your job to maintain a large list of qualified officiants, because the other thing is a marriage license is good, even though it's issued by a Bucks County official. It's a Pennsylvania marriage license. So if you're getting married in Pennsylvania,
Right.
you get your license in Bucks County, you can go to Erie, you can go to McKean County, you can go to Tioga,
Right.
you can go to Philadelphia, you can go anywhere you need to use that license, as long as it's within the borders of the Commonwealth. My wife would have to split my estate with my children. So she would get 50% and my kids would get 50%. And since they're minors, somebody other than my wife would have to be a trustee for them. So that could be a particularly thorny issue in those situations, especially when the person's intent may be that they want their spouse to get everything. Other type of situation is that it also presumes that your spouse will be the administrator of your estate, and if your spouse doesn't do it, then your children, then your heirs. So you just go down the family tree. Now, you may have children, if you have multiple children, one may be more inclined than the other, or you might not trust one of them. So a will allows you to determine who is going to be that personal representative to the exclusion of another person. And since it's so common to have only one personal representative and not have all of the children, you might not necessarily have to, it might not be insulting to that excluded child, because it doesn't change that child's gifts under the will as to who the administrator is, whether it's a brother or sister, or whether it's a lawyer, a professional, an aunt and uncle. Whatever the instructions in the will are, those are the instructions that that personal representative has to follow. And if there is no will, they have to follow the intestacy law, which basically follows the bloodline. Now, what's interesting is that the Commonwealth has grafted itself onto everybody's family tree. So by the time you get past the second cousins, as far as a family tree goes, if you can't find a relative closer, second cousin or closer, then the Commonwealth is your heir. So if you want to stop that, you definitely want to.
Let's get one other question.
Well, the thing that we usually see a lot of attorneys saying is just doing is mentioning the person in the will.
Right,
Either saying, I have purposely excluded this person for reasons best known to them.
okay.
Sometimes people like to go out why they're excluding the person. Whether that's they're a person of means already and they won't benefit from my gifts, or whether that is that darn rotten and I remember, whichever way.
Whatever
But
way.
the most important thing is not so much that you give a nominal gift to the person, so much as they're mentioned
Okay.
and it's shown to be a deliberate act, so the
Right.
person can't say, hey, they just forgot me.
Right, exactly.
Right, okay. Well, I think we've learned a lot today, and I want to thank everybody for, excuse me, tuning in. But more importantly, Don, you've just been a font of information, and we know that we need you back because there's a lot we didn't cover today.
Well, it's been fun. Thank you, Kevin. I
Thank
appreciate
you
the
very
opportunity.
much. All right.
Have a good
All
day.
right. Thank you. And thank you. And just join us next time right here on Central Bucks Senior Task Force TV.